Welcome to our Regulation Mastery session. In this session, we will continue reading the CSSF Circular 22-806 from Part 1 Outsourcing Arrangements, Chapter 4. Governance of Outsourcing Arrangements. Subsection 4.3.2.4 Termination Rights. 101. The outsourcing agreement shall expressly allow the possibility for the in-scope entity to terminate the arrangement in accordance with applicable law, including in the following situations. A. Where the service provider of the outsourced functions is in a breach of applicable law, regulations, or contractual provisions. B. Where impediments capable of altering the performance of the outsourced function are identified. C. Where there are material changes affecting the outsourcing arrangement, or the service provider, e.g. sub-outsourcing, or changes of subcontractors. D. Where there are weaknesses regarding the management and security of confidential, personal, or otherwise sensitive data or information, and E. Where instructions are given by the in-scope entity's competent authority, e.g. in the case that the competent authority is caused by the outsourcing arrangement, no longer in a position to effectively supervise the in-scope entity. 102. The outsourcing agreement shall facilitate the transfer of the outsourced function to another service provider, or its reincorporation into the in-scope entity, whenever the continuity or quality of the service provision are likely to be affected. To this end, the written outsourcing agreement shall A. Clearly set out the obligations of the existing service provider, in the case of a transfer of the outsourced function to another service provider or back to the in-scope entity, including the treatment of data. B. Set an appropriate transition period, during which the service provider, after the termination of the outsourcing arrangement, would continue to provide the outsourced function to reduce the risk of disruptions. C. Include an obligation of the service provider to support the in-scope entity in the orderly transfer of the function in the event of the termination of the outsourcing agreement, and D. Without prejudice to applicable law, include a commitment for the service provider to erase the data and systems of the in-scope entity within a reasonable time frame when the contract is terminated. 103. The outsourcing arrangement shall not include any termination clause or service termination clause in case of bankruptcy, controlled management, suspension of payments, compositions and arrangements with creditors aimed at preventing bankruptcy, or other similar proceedings. In particular, in the context of BRRD institutions, clauses triggering the termination or service termination because of resolution actions, reorganization measures, or a winding up procedure, as required in accordance with the BRRD law are not allowed. Section 4.3.3 Oversight of Outsourced Functions. 104. In-scope entities shall monitor, on an ongoing basis, the performance of the service providers with regard to all outsourcing arrangements on a risk-based approach, and with the main focus being on the outsourcing of critical or important functions, including that the continuity of the services provided under the arrangement and the availability, integrity, and security of data and information are ensured. Where the risk, nature or scale of an outsourced function has materially changed, in-scope entities shall reassess the criticality or importance of that function. 105. In-scope entities shall apply due skill, care and diligence when planning, implementing, monitoring and managing outsourcing arrangements. 106. in-scope entities shall regularly update their risk assessment in accordance with points 66 to 70, and shall periodically report to the management body on the risks identified in respect of the outsourcing of critical or important functions. 107. In-scope entities shall monitor and manage their internal concentration risks caused by outsourcing arrangements, taking into account points 66 to 70. 108. In-scope entities shall ensure, on an ongoing basis, that outsourcing arrangements, with the main focus being on outsourced critical or important functions, meet appropriate performance and quality standards in line with their policies by a. Ensuring that they receive appropriate reports from service providers. b. Evaluating the performance of service providers using tools such as key performance indicators, key control indicators, service delivery reports, self-certification, and independent reviews, and c. Reviewing all other relevant information received from the service provider, including reports on business continuity measures and testing. 109. In-scope entities shall take appropriate measures if they identify shortcomings in the provision of the outsourced function. In particular, in-scope entities shall follow up on any indications that service providers may not be carrying out the outsourced critical or important function effectively or in compliance with applicable laws and regulatory requirements. If shortcomings are identified, in-scope entities shall take appropriate corrective or remedial actions. Such actions may include terminating the outsourcing agreement with immediate effect, if necessary. 110. In-scope entities shall inform the competent authority with no delay of material changes and/or severe events regarding their outsourcing arrangements that could have a material impact on the continuing provision of their business activities, to allow the competent authority to assess whether regulatory action is needed.